Petition is the initial review of petition alleging that a county officer violated Section 2-83B, under fair treatment of the Code of Ethics, when the officer, in conspiracy with others, illegally obtained and used $10 million of the people's money for the sole advantage of Bank of Hawaii, First Hawaiian Bank, and or a RICO Enterprise of the Old Boy Network and or unmentionables. Mr. Cole.
Yes, I believe I've been trying to bring this to the attention of this board since November the 8th of 2008. Unfortunately, Chairman Dill is not here. So I remind him that currently there's an ongoing investigation out of the State Attorney General's Office and the Office of Information Practice, identified as S Investigation-G 10-1. As none of you will recall, because you weren't here, in June of 2009, I appeared before this board, only to find out that secret letters of extortion had been sent to board members prior to my appearance. And apparently information confidential to this board had been released to the public, where public statements were made prior to the board. So in order to caveat this, I would like to, I ask any of you if you've received any letters of extortion or letters explaining or requesting you to make a certain decision, or if the decision has already been made prior to this meeting. This will be investigated and added to the current investigation as per my email from Lyndon Jostein, staff attorney of the OIP. Hearing none, I assume that you haven't made your decision and decided to recuse yourself from this meeting. I come before you, it is not a question, as I said before, of the criminal actions identified by Corporation Counsel Ishida. Corporation Counsel Ishida, in electronic verification of emails under the Uniform Information Practice Act, sent me the very documents of the issuance of the bonds, of the issuance of the IRS tax form exemption of bonds identifying $3 billion of refinancing bond Series B, issued me, gave me the copies of the actual bond issued with the cusp number bearing the signatures of Billy Kenoi and Nancy Crawford. The communications between Bank of Hawaii and County of Hawaii bearing the signatures of Michael Okamoto, the treasurer. It must be noted that Michael Okamoto, prior to becoming treasurer County of Hawaii in 2000, was a senior executive Bank of Hawaii. In continuing, the question before this board is one of ethics. Did Mayor Kenoi violate the ethics code by giving proprietary and sole proprietary access to assets of the people, identified as $10 million, that was obtained through the verified and defined illegal action by the very Corporation Counsel of the County of Hawaii in verification? I questioned the very fact that this could not have happened. Mayor Kenoi could not have sold $10 million of Series B bonds on March the 2nd of 2011 under the authorization of Bill 311 Draft 3, because Bill 311 Draft 3 had not been approved or authorized by the County Council. As required by the charter, all sales of bonds must be authorized by the Council. In response, Mr. Ishida, in electronic verification, did in fact confirm that the $10 million bonds were in fact sold prior to being authorized by the county. That is not a question of fact here whatsoever. Okay. The question of the fact is, what value did the people of Hawaii get for the $66,000 they paid to Bank of Hawaii for the purpose of having that $10 million wire transferred from Bank of Hawaii on March the 2nd of 2011 to the First Hawaiian Bank on March the 2nd into bank account? Here's the exact deposit slip. Here's the exact bond sold with the cusp registration number as on file and held in New York Mellon Bank, 1 Wall Street, 3rd floor, window A. On March the 2nd, 2011, cusp number 41969 CAE6 with a maturity date of September the 2nd, 2011. On that very same date, the money, $10 million, was used to open a certificate of time deposit, First Hawaiian Bank, account number 200100201 for a period of 184 days with a maturity date of September the 2nd, 2011, identical to the maturity date of this bond, March 2nd, 2011, at an interest rate of 0.1225%, which is 1/10 the interest rate that the county of Hawaii, the people of Hawaii, were paying to Bank of Hawaii. I guess we'd make a profit on volume on this, wouldn't we? In addition, I was sent the actual copy of the bill with the signature of the mayor on it. Again, we go, all right. Now, what we don't know, or what isn't said here, is the information I got is there's also a set of Series A bonds issued for $10 million. When questioned as to what happened to all the information of request offering of bonds, the County of Hawaii only offered bonds to Bank of Hawaii. The County of Hawaii did not offer bonds to any other financial organization to see if we could get a better rate. Okay, that in itself is a violation, but unfortunately, due to a bowling conflict on a team membership, that couldn't be heard by this council, apparently. Now, Chair Balser, excuse me, you are a financial manager, so you are very much aware of the violations of the Security Exchange Commissions, the state and federal laws on bank fraud. I have no point here. What I'm asking and what I'm requesting under the pureness of the jurisdiction of this body is to allow this case to go forward, this hearing to go forward into a formal hearing where individuals may be subpoenaed and sworn oath taken, where Mayor Kenoi may sit here before you, swear an oath, and tell the people of Hawaii why he sold $10 million worth of bonds without the authorization of council, why it was in the county's interest, in the people's interest that he was elected to support. How is it in their interest that Bank of Hawaii was able to use $10 million of their money at 1/8% interest while they were paying 1.25% interest? What value does it have to them? So I request that you approve this petition to go forward for a formal hearing so that rules of discovery under the Hawaii revised statutes and the court rules may proceed. However, I understand, and I would be totally shocked if you actually went through, but I cannot understand that this committee or this board would allow this to go forward due to personal or the influence of racketeering and corruption and public corruption. Do you have any questions?
Are there any questions from any of the members of the board at this time? I have a question for you. You're referring to the sales of the bonds, and I remember not extremely specifically when the matter came up as to how the county structured the short-term monies before the long-term bonds were being purchased by others. Are you referring to the short-term bond, or are you referring to the long-term issuance?
That has no bearing here whatsoever. However, I will answer your question. The county charter states that under section 6-6-1 Organization, Department of Finance. Under Section 6-6.3, Powers, Duties, and Functions. Under C of that section, it states, negotiate loans and issuance and sale of bonds and notes when authorized by the council, maintain records of county indebtedness, and have charge of the payment and interest principal thereon.
Okay, so, but the question has to do with if I recall, there were two facilities that were structured by the county of Hawaii.
The facility of the sale of bonds was a traditional bond float. The sale of bond anticipation notes, by its very definition, is a short-term sale in anticipation of the sale of the bonds, and that was clearly defined in today's article in the Tribune Herald by Nancy Crawford.
And so,
Nancy Cooper.
So the issue that you have is with the bond anticipation notes.
The issue I have is the fact that the bond anticipation notes were sold prior to the authorization. In other words, there were no bonds upon which you could sell an anticipation note to.
Where was the facility or was the facility approved in terms of a function that the county could go by?
No.
So what you're saying is the county council had absolutely no knowledge of the bond anticipation notes prior to that issue.
My discussion with Dominic
I'm not talking about the specific transaction. But
my discussion with Dominic Igong, he did not know that Mayor Kenoi had sold $10 million of bond anticipation notes prior to May the 4th when the bond was approved for sale. In other words, what you're trying to do, I believe what you're trying to do is say that in order to sell a bond anticipation note, you are selling a note in anticipation of a sale of a bond float, a general float. The anticipation note is used for basically arbitrage or for short-term monies needed for a project. If there has been no bond authorized for future sale, then the sale of a bond anticipation note upon an authorized bond cannot be sold legally. In other words, if the county did not approve the sale of the $56 million bond for the projects identified, then there would have been no bond upon which an anticipation note could be issued. In addition, the county explicitly and pointedly stated that the monies for the bond of Bill 311 Draft 3 were identified specifically for the projects. Therefore, the mayor must identify how or what specific project upon the authorization of the bond was used to justify buying a $10 million time deposit bond or time deposit note from the Bank of Hawaii. There is no authorization. It did not go to any approved use of the money. So therefore, it would be illegal on multiple counts. And since the money was not used as required for the specific bond issuance, in other words, what item of the bond, in fact, if you'd like to, I can read the actual bond here.
That'll be okay.
What item of the bond did the $10 million that the bond anticipation refinancing note Series B? Series B, I understand, is a refinancing note. Okay? So we have never issued a Series A, apparently, because I found out they said it was a typo. And Bank of Hawaii issued the County of Hawaii $10 million loan on a typo. That's language. So not only do we have to determine what value the people of Hawaii got for their $66,000 interest, but what item of Bill 311 did in fact the bond anticipation note be issued for? That can never be answered either because there was no authorization.
Any comments or questions from the rest of the board? Is there any thoughts of where we shall proceed with this?
municipal. Yes, the documents you referred to 0311 and the email Lincoln.
Emails from Lincoln Shooty, yes.
Did you submit any copies of it?
Yes, I have. In fact, if you look at my petition, I actually had presented those to you in public. And you had received those documents numerous times, as a matter of fact. I think I actually stated here are the documents that I proved this, and I have issued them to you, I think. Okay, let's see. In fact, I refer to page 2 of the minutes of the regular session of Wednesday, July the 11th to 12, where I state, quote, here's the exact illegal bonds being sold by the mayor and Nancy Crawford, the deposit slip from the Bank of Hawaii to First Hawaiian Bank, the return of principal of the First Hawaiian Bank, and the federal IRS forms of tax-free obligation. They're on file with your board here. So if you review your the actual filings and the testimony I've made, you will see all these are in there. You will also notice that they're also in there, and as I identified, from my petition for Nancy Crawford. So you are well aware of all this information. However, if you'd like more copies, we can have them electronically transferred to you, but this should be brought up in a formal hearing.
I wanted to point out, I believe the reason we don't have that right at this time, and they were submitted in the past, and please correct me if I'm wrong on this, the matter previously was specific, whether or not there were conflicts of interest in deciding who the vendors were going to be with regards to the facility for the anticipation bonds, anticipation notes, excuse me. Mm-hmm. And so what had happened is one issue, but looking at how the vendors were selected was the issue of communication. So at that time, you may have not looked at that particular aspect of the transaction. And so now you're asking us to look at the specific transaction to determine legality or illegality.
No, the legality or illegality is not the jurisdiction of this board.
Correct.
The legality or illegality would be held with the county council if they determined that there was sufficient grounds for a misdemeanor violation of the Hawaii County Charter. It is the the county council's obligation to file a criminal complaint. What I am asking before this board is what value, what did the people of Hawaii get for the $10 million that Mayor Kenoi gave to and proprietary to the First Hawaiian Bank? The people of Hawaii paid $66,000. This is no difference than if Mayor Kenoi decided to use $10 million of heavy equipment from the Highways Division and $66,000 worth of manpower and fuel to clear his subdivision that suddenly got approved when he appointed a new planning director. There is no difference. This is what did the people of Hawaii get in return for their $66,000 that the First Hawaiian Bank had proprietary use of. Proprietary use. This is not the illegal, this is the ethics board. So that's why I'm requesting. In discovery before the ethics board, in formal hearings and subpoenas, it will come out any violations or criminal violations. That would be the purview to be forwarded on under the United States Code, Criminal Section 18, subsection 4, misprision of felony, that you are obligated to do. However, the ethics complaint merely states, ready and have been denied many times.
Counsel, can we just simply request an answer to that question?
Well, Mr. Cole brought up the fact that he had brought similar allegations against Nancy Crawford last time, and I believe the petition was filed in early 2011, and substantially similar allegations with respect to the bonds.
They are not similar allegations, Counsel.
Testimony was provided and the board did dismiss this matter. So if you want to review those minutes, you review the order dismissing, you can provide you with that, or whatever other questions you have.
Counsel is an error. That is not what the petition for Nancy Crawford was about. The petition for Nancy Crawford.
I understand. Yes. I would like to review those. What I would like to do is very simply ask the mayor's office, and they can submit in writing. Nobody has to show up. I want to find out the benefits. We're looking at the benefits of that transaction. Period.
Okay, can you spell out what transaction specifically so that I can formulate a question?
Yes, it would be easier for me to write it down and give it to you.
Okay, so you're asking for to continue this initial review of the petition?
Yes, a continuance of the initial review. Do I hear a motion to go with that? A second? All those in favor? Aye. So we're going to continue to get an answer from the mayor's office on that. I think at this point we can move on to the next agenda item. Thank you, Mr. Cole.